Of second-degree murder after having been charged with first-degree murder. I won't really go into the facts other than just to remind the court this was a shooting that happened after a night out at a bar where there was a number of intertwined, interrelated people with lots of complicated interactions, at least 2 physical altercations inside the bar and outside the bar. Was really not in dispute that the end of the evening involved Mr. Black, who was driving his car, pulling around, coming into contact with Mr. Lee, the decedent. Mr. Black's car stopped. Mr. Lee approaches, yelling out, and approaches the side, the driver's side window of the car, and a shot is fired. That is, at least that part is essentially on surveillance video. The defense obviously was self-defense. Just those are the facts. There are 4 issues I'd like to talk about, if I can, some more detailed than the others. The first issue, and I really don't want to argue this issue, I just want to mention it because it's important. And this has to do with, if the court's read the briefs, will have seen that I have raised a number of issues about the way the state approached the defense, in particular defense counsel. Hopefully the unusual nature of those factual scenarios is apparent from the briefs. But if not, I urge the courts to read the transcripts carefully. I have read many trial transcripts. I've never seen one just like this. This was very much, it became very personal. There were a number of attacks made by the state on defense counsel by name. There were accusations of essentially misconduct, of tricking, of showing phony images. So as the court reviews the record, I just commend the courts to take a close look at that because I think this case stands out for that reason. In terms of the legal issues I want to argue today, I want to begin with an issue relating to questioning of the defense expert, Dr. Allen. Now, Mr. Black did not testify in this trial, as was his absolute right. It is well settled that not only does someone not have to testify, that there can be no inference drawn from their failure to testify. Griffin versus California, State versus Jackson in our courts, the state can't gain a benefit from a defendant's failure to tell his story. The state can't comment on that failure either intentionally or can't present a comment, as was said in Jackson, that the jury would necessarily have understood to be a comment on the failure to testify. To go back to Dr. Allen. Dr. Allen testified as an expert essentially on the effects of cocaine and alcohol consumption. Mr. Lee is seen on the surveillance video in this case and was testified, there's testimony from one of the people who in his party that while he is at this bar, not only was he drinking, but he was consuming an amount of cocaine. Dr. Allen explained the effects of cocaine. It can make you more aggressive, can make you have heightened senses responsive to what around you. He talked about the cumulative effect of cocaine when combined with alcohol. And he described watching the video, surveillance video from the bar of Mr. Lee and the ways that that was consistent with someone experiencing this heightened sensitivity and sort of forceful, aggressive actions. The prosecutor, again, a very experienced prosecutor, cross-examined Dr. Allen and highlighted over and over again the fact that Dr. Allen had not talked to Mr. Black. He said, defense counsel said you've never spoken to Hank Black, you make an opinion about the victim, about his aggressive behavior, and you're employed by this person right here, the person who encountered him. Wouldn't it be important for you to talk to him? You didn't talk to any of the witnesses, including the person right here who's on trial. So over and over again, this is not a slip of a tongue. This is not something that just kind of came out. This is the line of attack of the prosecutor, is not really to point out that Dr. Allen's opinion wasn't, there were a lot of people he didn't talk to. The one that the prosecutor wanted to emphasize over and over again that he didn't talk to was the defendant. And we suggest that whatever the prosecutor's intent was, there is no way that the jury is not going to interpret that as suggesting Mr. Black isn't telling his story to anybody because his story is harmful. And that's the inference that is prohibited by the Fifth Amendment.
The question I have, I guess, for you is in approaching an expert, and obviously the jury is the ultimate fact finder. And the jury charge, when it comes to expert witness, is that they're not required to accept the testimony of an expert. They can judge it against the facts, they can judge it against the foundation that the expert based his opinion on, and they can reject that opinion if they feel like the opinion doesn't conform to the facts, or that the opinion was based on information or lacked information for which to come to the conclusion it did. So in cross-examining an expert, you can get into what the expert based his opinion on, what facts, and then also what facts the expert didn't consider. And in some cases, situations about dealing with a person's reaction on drugs or how they were acting, it wouldn't seem totally unreasonable for a question to come up with the expert about, well, did you talk to Mr. Black about how this person was acting around him, to get his information, to get information from other people? Because I think he said he didn't talk to anybody who was present, who had actual interaction with the victim and how that victim was acting. And that was, at least that's the impression I got from reading it, was where the prosecution was going, was based on how he came to his opinion and what information he didn't consider.
So I would agree with almost everything you said. I don't think that's where the prosecutor was going. But yes, absolutely, he's entitled to cross-examine the expert about the basis of his opinions. So Mr. Lee had been at the bar for a number of hours, had been around a lot of people.
Right.
Had the prosecutor been asking, you didn't talk to Mr. Jackson, you didn't talk to Ms. Hayes, you didn't talk to all these other people, actually spent a lot of time with Mr. Lee, and had mentioned as part of that, and you also didn't talk to Mr. Black. I think then we have a legitimate cross-examination about the basis of the opinion. He doesn't ask about those other people. The person he asked about is, you didn't talk to Mr. Black. Mr. Black had just a limited interaction with him, half a second. It's not the first one you would have talked to. But he makes that point, and he makes that point over and over again. Not these other people, but you didn't talk to this guy right here. But I think, and I hope I made this in the reply brief, I think that to the extent there's any doubt, that kind of goes out the window when you see what the prosecutor actually said. Because when he starts this line of questioning, he says, okay, Ms. Akers, defense counsel, said, you never spoken to Hank Black? No. And he says, okay, and don't you think that the jury obviously would want to hear, and then he stops himself, right?
The judge gave an instruction.
The judge didn't give an instruction right there. The prosecutor switches and goes back to, well, actually, we're talking about who you didn't talk to. The judge eventually does give an instruction. I would point this court to the Jackson case, Nora Jackson, in which there was a curative instruction there too. And Tennessee Supreme Court said, this is the thing that a curative instruction can't really cure. You can't plant that idea, and that's absolutely what this prosecutor was doing. And as I said, whether he thought he was being especially clever by mentioning, or it was slipped out by accident, when he says, don't you think the jury obviously would want to hear after having just been talking about not talking to Mr. Black, that's what you can't do. If I could turn to the next issue, this is the self-defense duty to retreat issue. As the court's aware, after Perrier, we have sort of a threshold decision that's made by a trial judge as to whether one of two possible regimes apply. A defendant has a duty to retreat before engaging in force, if possible, or no duty. As the cases we are relying on here, a case from this court, State versus Tyshawn Booker. In the Booker case, this court explained that that threshold determination, which in the statutes talked about engaging in unlawful activity, that doesn't mean any and all unlawful activity. There has to be a causal nexus between the alleged unlawful activity and the, I want to get this right because it's important, has to be a nexus between the unlawful activity and the need to engage in self-defense. The unlawful activity has to provoke, cause, or produce the situation. So the court in Booker explained, Booker was a similar case except juvenile. The court said, being a juvenile wrongfully in possession of a firearm can't be the unlawful activity that sends us into the duty to retreat situation. In that case, there was a robbery. Robbery certainly could be the unlawful activity. Here, the alleged unlawful activity that the trial court relied upon to instruct the jury on a duty retreat was felon in possession. And that is exactly what this court in Booker said can't provide a causal nexus because it's a status. And the way to think about that is the fact that Mr. Black was a felon in possessing a firearm. That's not what caused the confrontation. That's not what caused him to have to engage in self-defense. Ultimately, that's what led to Mr. Lee's death, but that didn't produce the situation. It's not like there was a robbery that produced the need to engage in self-defense. It's not like a drug dealer engaging in a drug transaction and then needing to engage in self-defense. This is a status offense. This court has, in 2022, reiterated in James Lee Simpson, again, status offenses, this is a quote, status offenses such as being a felon in possession of a firearm will rarely qualify as unlawful activity because a person's status alone cannot provoke, cause, or produce a situation. So I think on that precedent, we clearly have an erroneous jury instruction. The question is then, is it harmless? The state claims that the evidence is such that it didn't really matter. This is, I point the court to closing argument. The prosecutor argued duty retreat. It's one of the last things he said as a substantive argument. And I think also think about the actual situation. The jury could have concluded that Mr. Lee responded aggressively, went towards the side of the car. There was testimony he had his hands raised up. Clearly was doing something with his hands. There was testimony that there may have been something that either was a weapon or looked like a weapon in his hands. A jury could have found that in that situation that Mr. Black had a fear, a reasonable fear, but the jury could have believed that if he was under a duty to retreat situation, that his only available course was to drive off. Whereas if he's not under a duty to retreat situation, even if you're sitting in your car and you could drive off, if you don't have a duty to retreat, someone's coming at you dangerously and aggressively, you're entitled to defend yourself. So this is a case where whether or not there was a duty to retreat, I think, could have been outcome determinative. And under Booker, under Simpson, the wrong regime was applied here. Finally, I want to talk briefly about the instructions on second-degree murder, voluntary manslaughter. I have set these out, a number of arguments about them in the brief. I am happy if the court wants to read my brief. I'm also happy if the court simply wants to read Judge Witt's opinion in Brandon Scott Donaldson, because he makes all of the points that I tried to make probably better than I have. Our system for defining voluntary manslaughter and second-degree murder simply doesn't work. There's one particular issue, which is second-degree murder has two elements: knowing an unlawful killing, voluntary manslaughter, knowing an unlawful killing in a state of passion. And our order of sequential instruction provides when you have a greater offense and a lesser offense, you can only go from the greater offense to the lesser offense if you have a reasonable doubt as to one of the elements. So logically, you can't get from second-degree murder to voluntary manslaughter. You can get to second-degree murder down to something else, or you can stay at second-degree murder, but you can't go from here to there. I think the panels of the court have at some points kind of decided there's something implicit in that structure that if you have a reasonable doubt as to the state of passion, that actually, even though the sequential instruction doesn't say that, you can still go to voluntary manslaughter. I disagree with that. But putting aside my disagreement, here there was a request by trial counsel for an instruction that would have made that clear. Trial counsel said, let's tell the jury that if they find a knowing and unlawful killing and they find it was committed in a state of passion produced by adequate provocation, that they are supposed to return a verdict of voluntary manslaughter. I have not heard the state say that that is not a correct statement of the law. I don't think the state can point to anywhere that that is said in the instructions. And if somehow that's implicit in the instructions, then absolutely, when we have a proper request to let's tell the jury what they're supposed to do, because otherwise they may think it's up to them. Is it second-degree murder, voluntary manslaughter? We just get to decide, or maybe we think we have to go to second-degree murder. Here there was a request that even if you reject everything else I've said about the instructions, that request is correct. This is the correct outcome if you find it was committed in a state of passion. The trial judge refused to give that instruction. I will reserve the rest of my time for rebuttal.
Is that proposed instruction by defense counsel, is that in the record?
Yes, that's at page 84 in the record.
All right, thank you. General, good afternoon.
Good afternoon, Your Honors. Ben Ball on behalf of the state. I'm happy to go through the facts on this one if you have any questions about it, but as it is, I'll just dive on in the order that the defendant's taken these.
Dive on in. We've read the facts on the brief, so we're good on that.
Well, so then I'll start with this argument about this allegation that the prosecutor commented on the defendant's right to remain silent when cross-examining this expert witness. The trial court here properly found that that's not what happened. This witness was questioned about the basis of his opinion. Judge Campbell, as you noted, this is a pretty common line of questioning with an expert. We often see it when there's some sort of insanity defense, where there's a mental health expert who testifies about someone's mental health, and there are questions about, did you speak with the person? This was about the basis of the expert's opinion, because he had watched a video. And Your Honors are going to watch these videos, and I'll tell you, there are a lot of videos. Obviously, the most important video is that the shooting is captured on camera. We also have quite a bit of video from the bar that night. The expert has watched this video at the bar, and there indeed is video footage that seems to suggest that Mr. Lee and his friends are consuming cocaine in this bar, as are quite a few other people at this bar, it appears. But what the expert didn't do was talk to anybody who had been in contact with Mr. Lee. And he does ask the expert if he spoke with the defendant, but he also says, or anybody who had been in contact with the victim. That's an important thing to do. It's something the jury would want to know.
Okay, let me ask you this, because having done that in my career, dealing with experts on insanity cases, the questions about the mental state of the defendant, the expert's is going to ask the defendant, are you going to want to know, did you talk to him about, about what he was thinking or what was going on at the time of the offense, as to base your opinion. Did you ever talk to the defendant to find out? And it's because he's basing his opinion on, or he's making an opinion based on the mental state of this particular person, this particular time. In this case, they're talking about somebody else. They're not talking about the defendant's mental state. They're talking about another person, the victim's mental state.
That's right.
So does it carry the same, I basically almost call it an exception from the standpoint that, you can talk about, since the defendant's mental state is the issue, what he tells his doctor becomes incredibly important. If the doctor doesn't even make an attempt to talk to him, that becomes very important. What about another party? If another party is the subject, can you start asking questions about what the defendant's thoughts were? Is that relevant?
Well, I think the relevant question is about the basis of knowledge, not necessarily, inquiry into, sort of a shadow way to produce a statement or anything like that, but the basis of the expert's knowledge. Did you speak to people who were there?
Okay, that I understand, and I think that's a very good line of question on an expert. But, and I think the defense would agree up to a point, but the defense is that he went too far. He's, the comment about, wouldn't you like to hear what the defendant had to say kind of thing. Isn't that going too far?
Well, Your Honor, the defendant is relying on essentially an unfinished question. I mean, there's a course correction there during that, and there's ultimately no question, put to the witness and answered along the lines of, wouldn't they want to hear what the defendant had to say about the offense? And the line of question is essentially, wouldn't they want to know that you had spoken to the people who've been there to form the basis of your opinion? Not a suggestion that the defendant should be telling his story to the jury.
Okay, I understand that, and that may have been the intention. But how do we assess the ultimate issues about the way that would be taken by the jury?
Well, I mean, I think Your Honors can look at these questions and see that any reasonable jury would not have taken from this that the defendant is being assailed for not testifying. This is an attack on the basis of knowledge of the expert. And the jury, as Your Honor pointed out, is going to be tasked with deciding how valuable this expert opinion is to them, with accrediting this expert or not accrediting this expert. And that's a relevant line of questioning to get into. And, while the questioning was sharp, it ultimately did not cross that line. I think the trial judge was correct in its ruling here. The prosecutor's intent was not to do that, and I don't think a reasonable jury could reach the conclusion that the defendant's right to remain silent was being impeached.
That's right, but, the question that I think following up what Judge Campbell said, did you speak with anybody who was there? I mean, obviously the defendant was there. He's on the video and he's there. So that would include the defendant, but there was really no need to single him out with this expert testimony versus the insanity or a focus like Judge Campbell was talking about, right?
Certainly, he could have asked the question more broadly, and I know the defendant, my friend on the other side here points to numerous witnesses that weren't mentioned. Quite frankly, Your Honors, there are a lot of witnesses in this cases. I have to make myself a little bit of a cheat sheet here in case they came up to remind me who everybody is, and distinguishing between who is Ms. Hall and Ms. Morrell and all that. I can understand why the prosecutor might focus on the one person that he knew who that was. But he did ask the question, or anybody else, and that encompasses all of these witnesses, and that was the focus of that questioning, not why didn't the defendant testify. So turning to the Perrier issue, I think this court is well aware of the state's position as to the current situation with precedent on the nexus requirement. I don't want to beat a dead horse on that one, but it's the state's position that there is no binding authority. There's a split essentially, and that you're not required to use this nexus requirement. But even if so, I think that the nexus here exists. But ultimately, we say to this court, it doesn't matter. No reasonable jury, upon watching the videos here, upon entertaining this evidence, could come to the conclusion that the defendant acted in self-defense. And Your Honor is going to watch these videos, and they show the crime. This is not someone acting in self-defense. This is a defendant who almost strikes the victim with his vehicle. When that happens, the victim, he does move, whether it's towards the vehicle, he's moving sort of forwards, the direction he had been moving, and he throws his hands into the air. a gesture that I think, most people would probably do had they just about been hit by a car. No sooner does he throw his hands into the air and the jury can see his hands, and he does not have a weapon. He's shot by the defendant. No reasonable jury is going to conclude here that this defendant is acting in self-defense. And turning to the issue of the sequential jury instructions and how we charge voluntary manslaughter. The law here is fairly established in State v. Moore. This court has seen this argument multiple times, and no panel of this court has adopted the argument put forth by the defendant here. I understand that the defendant is pointing to the specific jury instruction that he requested. I would point to this court to the jury instruction that was given, and that which is the pattern instruction that this court has affirmed, because when we look at the instruction given on second-degree murder, the jury is also instructed on the difference between second and voluntary manslaughter. So the jury understands that there is this issue of whether there was passion brought on by adequate provocation. When they're considering second-degree murder, this court has long upheld that. I understand the arguments that my friend on the other side is making. I think those are good policy arguments for the General Assembly. But as it stands, this was a correct jury instruction.
Was the instruction, the pattern instruction that I'm familiar with, has the provocation, passion, provocation, as part of the second-degree murder charge, and then it's also repeated in the voluntary manslaughter charge?
That's correct, Your Honor. So any reasonable juror reading these, jury instruction understands when they're considering second-degree murder that they have to consider whether there was this provocation supported by adequate passion at the time. So this jury instruction was the jury instruction that has been long affirmed by this court. For the remaining issues here, if there are no other questions on those issues, I'm happy to answer questions about any of them. Otherwise, the state would rest on its brief for the remaining issues. If there are no further questions, I would ask this court to affirm the judgment of the trial court.
Thank you,
Thank you,
General
Your Honors.
I have three quick points to make. One, again, drawing on some of the questions, to the extent that there are people in the bar who had interactions with Mr. Lee that could have commented on whether cocaine seemed to be affecting him or not. Mr. Black was among the least of those. There's no indication he actually spoke to Mr. Lee in the bar at all. Him seeing him after he took cocaine was just in the parking lot. So the same point I was making before, there's a specific decision to focus this supposedly basis of opinion cross-examination line, focusing on the one guy really wouldn't have been that helpful to speak about. The more important thing, and again, to take the court back to what Supreme Court said in Jackson, we can look at the prosecutor's intent. I think we have a great piece of information as to the prosecutor's intent. But even if you don't decide that the prosecutor had an intent to comment, you look at whether the remark was such a character the jury would necessarily have taken it to be a comment on the defendant's decision not to testify. You have a line of question. Ms. Akers said, "You've never spoken to Hank Black." No. And don't you think the jury obviously would want to hear, even if it's cut off at that point, a jury is going to have its minds drawn to Mr. Black's failure to tell his side of the story. I would point out that the state seems to be suggesting, it wouldn't have crossed anyone's mind that that's what was being brought up. Defense counsel objects. They go to sidebar. Trial judge doesn't say, what are you talking about? What are you objecting about? As soon as they get there, trial judge knows what the problem is. The trial judge ultimately says, that's not improper, but it is clear to everybody, they know what is going on. This is not like the trial judge saying, I have no idea what your objection is. There's nothing remotely suggestive has happened. And we're, again, focusing not on legal technicalities, but what are we planting an idea in the mind of the jury. The second thing to go to sort of the facts, again, I think I have a different view of the video. You see on the video a car come to a stop. You see Mr. Lee in front of the car making a moving relatively quickly, not out of the way of the car, but to the driver's side of the car where we know the window is down. There is undisputed testimony that he is yelling, "What the F," as that is happening. There's undisputed, well, there is disputed testimony as to what's in his hands. I can't see from the video if there is anything or not. There is testimony he raises his hands from the person who's with him. The officer said he put his hands down. You have fast movements, aggressive movements right at the side of a car. In an environment, literally a few feet away, there's a big melee going on, right? There are people fighting. There is all this going on, and it's our position that in that situation, the jury should have been allowed to decide under the correct statement of the law whether Mr. Black acted in self-defense based on a reasonable fear. The final thing is absolutely the instruction on second-degree murder includes an explanation of the difference between second-degree murder and voluntary manslaughter. So you have that bit twice. What the jury is never told is what to do with that. So they're told, while you're evaluating second-degree murder, you have to think about state of passion. And so presumably they do. They are never told, though, that if you conclude that there was state of passion, that second-degree murder is the wrong verdict and you have to go to voluntary manslaughter. A different part of the instructions, a sequential consideration instruction, kind of tells them they shouldn't do that. So at the very least, you have very conflicting ideas of what they're supposed to do. This special requested instruction would have cleared that up. It would have said, yes, in part of second-degree murder, you consider whether there's state of passion, and if you find it, the correct verdict is voluntary manslaughter. There is no reason that I can imagine of why we don't want to tell them that. If that's the law, why don't we tell them that? And here, was asked for, it was denied, and we don't know what they thought. If there's no further questions, we would ask that Mr. Black's conviction be vacated. Thank you.
All right, thank you. We'll be in recess for about 10 minutes.
All rise.